Marked on with an RA Allstein, please. In the matter of Central Car Company Limited and Jeffrey Bing.
I'm Mr. Murphy, ma'am. I would like to ask this court if I could have my learned friend as a Mackenzie friend.
Yes, I think there's no objection to that.
No issue. No issue.
I don't have any issue with that.
As you please, ma'am.
Well, I'm just coming a good distance away from you I won't do that now because I have found that it makes it harder for people to hear me.
On that footing, I might adopt the same, if I can confirm the report that I'm well and around the wrong way, as Mr. Murphy and Central Car Company have been covered, but it seems to be the wheels in so,
that's right with me. You happy sitting there? You can look closer.
Yes, ma'am.
there are just a couple of housekeeping matters if I can address.
You better wait for me to get my specs on it. Now what's your initial, Mr. Steele?
AJ.
And the Steele button on there?
No, it doesn't. No. Your Honour should have 3 bundles of documents
Thank you very much.
by the respondent.
Yes.
The other matter,
And it has Mr. Murphy got a copy of the phone?
yes, he does.
Right, thank you.
The other matter has been brought to my attention that in a previous hearing before this court, there was a recording made of the hearing for Judge Harrison. I don't know the ins and outs of that, but it's obviously something the court ordinarily wouldn't allow. And I just wanted to alert Your Honour to that in case you want to seek any assurances from...
What happened before Judge Harrison?
There was a recording made of the hearing before the judge.
What hearing?
An appeal hearing in which the Central Car Company, the appellant in this hearing, appeared. So I don't need to take too much time on that, just simply note that there was a recording made, and if Your Honour wanted to seek any assurances from the appellant here that there is no recording, that would be open to you.
I'm lost. So Judge Harrison has heard another case where the Central Car Company was involved. Is that
Yes,
what you're saying?
Yes.
Okay. Well, that might explain why I've ended up doing this case, because this case actually was set down in front of Judge Harrison. And not for that reason, but you know, he's recently had a health issue, and when I had no work schedule on leave for these 2 days, I went and spoke to him yesterday and said, should you really be here? I'm here and able to do any work you've got. And at the time he said that was all right, and then later in the day the file was brought into me. So I don't know whether it's because the judge felt that he should be at home or because it was better if he didn't do this case. I have no idea what the reason is. I didn't speak to him after I spoke to him yesterday morning.
I only flagged the issue, Your Honour, just because I know that Central Car Company is effectively self-represented here, and the rules of this court generally dictate that recordings are made of hearings.
No, not unless it's an appeal. That's are you quite happy about it with that?
Yes, ma'am. I did appear in front of Judge Harrison some weeks ago on a similar Consumer Guarantees Act claim, which we have filed a judicial review on, ma'am, in the High Court.
I see.
So I don't know if, I wish Judge all the best in a speedy recovery. I just do not know that if that was possibly the reason that he's handed it to you.
I can't tell you, but.
But that is under a judicial.
My best guess would be that, knowing that I was available and knowing about that, this is probably why we've all ended up here. And it's me, not him.
Right,
That
thank
would
you.
be my best guess, but I do not know. You don't know, do you, Steve?
No.
No. Okay. Steve, would you do something for me? Could you come and get that,
Certainly.
I certainly wasn't raising it as a point of recusal or anything, just simply noting that there was.
Well, it's worked out well.
It has, and I'm pleased that you're able to hear the case.
Yes,
So,
it's worked out well.
the other issue that I need to signal at the outset is about the scope of the appeal, which I received the submissions from the appellant yesterday, and don't make too much of the delay in that, but it does seem that the grounds of appeal have shifted quite significantly from what is contained in the notice of appeal. Yes.
Well, actually, the first thing I thought about that, and so I spent from about 2:30 yesterday afternoon reading this file. I haven't read absolutely everything. I have actually read both sets of submissions. But the first thing that did occur to me is whether the appeal from Central Car Company was under $12,500 or not, because there's a difference. So let me just talk to Mr.
I don't take that point, Mum.
You don't take that
So
point?
I don't take that point.
Well, what's your view of it?
There's a claim before the tribunal which exceeded $12,500,
Yeah,
which opens a jurisdictional door for this matter to be on
Yeah,
appeal.
that's what I thought, and the other thing was, with all the cost of the repairs, the 10 and a bit, plus the 2 and a bit.
I'm not sure that quite gets us there.
It does,
But
it does by about $200, I looked it up yesterday.
Maths is better than mine.
My maths is quite good for a lawyer. Right, yes, okay, so we don't take that point. So we're taking it that it is the broader jurisdiction of appeal and error of fact and law.
Yes, not simply the unfairness
Okay.
or procedural
Right.
ground. But I do take the point that, as I apprehend from the written submissions I have, that the grounds of appeal have been shifted significantly from what's contained in.
Well, there's not much in the notice of appeal, is there?
The notice of appeal is actually quite precise. I'd like to hand up, and I have a copy for my friend, and I don't want to take too much of Mr. Murphy's time on this, because I'm having to deal with my submission, but I have prepared a short memorandum which sets out
Okay, okay.
the respondent's objection.
So can you follow what's being said here, Mr. Murphy?
I will have to,
Yeah, so what Mr. Steele is saying, that what was in the notice of appeal about what your appeal was all about has changed a bit when he came to read your submissions yesterday. That's what he's saying to me. Do you understand that?
yes, ma'am.
In fact, it's not just changed a bit, the original grounds of appeal actually don't appear to be advanced
But what did they say?
now. Well, if Ron has done the one of
Yeah.
respondent's documents,
Mm-hmm.
it's on page 26 of that bundle mark.
Right, so they went through the 5 grounds of appeal and said we accept that, we don't accept that.
Yes.
Yes.
So, we don't accept the findings of the tribunal in relation to these
B, so it would be,
C, C,
B, C, and,
D, and E.
no, and E. B, C, and E.
There is a little D above E, mine on 27.
At all times is agreed to repair the instrument cluster, so there's no.
I'm not sure why it's in
Well, it doesn't
there.
matter. It's the same with 1A, isn't it? No change sort.
That seems to be the case.
Yeah, so the way I read
You
it
put
was
line
that-
through those, couldn't you?
Yes, so B, C, and E, those findings of the tribunal of what are being appealed. Have I got that right, Mr. Murphy?
Can I just,
Yes.
1 minute.
Place to me, that's right. It's just an adjustment. Okay. Sounds about right.
What changes does my learned friend
So,
think? What changes?
can you just confirm for me
Yes,
that in the notice of appeal document itself, which is at page 26 of the respondent's volume of documents bundle 1, that the things you are taking on appeal are the orders that the tribunal made under B, C, and E. So you don't contest the findings under A or D.
What does this engine more than rights? Yeah, you're looking at every single. Rectify the defects.
yes, ma'am.
Okay, thank you.
So if we proceed on that footing, as I apprehend from the written submissions, and it's probably for the appellants to develop the argument, but the relief now sought seems to be a cross-claim of some sort for betterment, additional repairs that have been carried out, and for compensation, which is not.
Betterment, yes, betterment, but that offsets the payment in E.
Yes, but not raised
In the notice.
in the notice.
That's not. So it's the issue of betterment, isn't it?
Well, there is, I'd accept there's an issue of betterment in relation to the front bumper, which is raised on the notice of appeal on page 27, Roman 6.
Okay. Okay.
Or Roman 5.
Called unjust enrichment.
Unjust enrichment, and the preceding paragraph 5, placed in a better position at the time than at the time of purchase.
Yep.
So, in relation to bumper, I accept the issue of betterment is raised by the notice of appeal. But it's not more broadly advanced in the notice of appeal. The notice of appeal,
So by setting out those costs to fix the vehicle that are in the submissions, that's wider than what's in the notice of appeal, is that what
not
you're
only is that wide demand, but that's evidence that has only just been received yesterday afternoon.
What's that?
It relies on a series of invoices that are produced and some
Oh, yes.
statements from the bar.
Statements from in
Well,
the submission.
in the submission.
Right.
So in that memorandum that I've handed to Your Honour, I made the point in paragraph 5 that a substantial part of the arguments for relief and the grounds are outside those contained in the notice of appeal. You don't need to hear the appeal before you can determine that, I think, but I just want to raise this issue
Okay.
so that you're alive to it and that you can address it with Mr. Murphy in fairness to him.
Okay. So it's really about So you only got these submissions yesterday?
Yes, I received the submissions
Yes,
yesterday
I think that's when we got them through.
and some additional evidence, the last of which came at 5:46 p.m. From the appellant. The submissions were due 10 days before the fixture, but I'm not going to make a big deal out of it.
And that first is the shocks.
Yes, other than 2 of those invoices, which I can identify, but there are only 2 of those invoices that have previously been put into evidence.
Okay, which one?
If you have the appellant's submissions,
Just tell me which of these 5.
the 2 that were in evidence are the invoice from New Day Motors dated 12 October 2019.
Right, I haven't got that one.
And an invoice from...
What's
Yes, if you've got volume 1 of the bundle, or correspondence bundle, there's a copy in there at page 77. It looks like
the Sterling Engineering?
New Day Motors is the one at page 77.
I don't know, it's got my little bundle here. I'll do it on here, that's all right. New Day Motors, yes.
And over the page at 78, as you want to see, there's an invoice from Sterling.
Mm-hmm. Right.
The rest of the invoices that Your Honour has in privacy are not in the evidence as far as I can ascertain.
I see.
And the reason I wanted to take you to paragraph 11 of the appellant's submission is there's a list of those invoices here, and I'm sure Mr. Murphy will come to this in the course of the submission, but I will object to those invoices coming in.
Right, okay, well, I just need to check it with Mr. Murphy. I don't have those, two. Were they in the bundle from yesterday?
They were in the document file, so
They're not in the bundle. So the bundle that came in yesterday, I've got one from the shop.
yes.
And on the back of that is something about alignment specialist Penrose, which I presume is the same place. A tax invoice from somebody. And one from Bentley Auckland,
yes.
one from the circuit specialist, one from Mesa
Yes, those were.
Automated.
That bundle was emailed to my instructing solicitors at 1:20 p.m. yesterday.
So that's all? Right, okay. Right.
But I'm conscious that the appellant should be given an opportunity to develop their case, and I can take the objections as they come.
Right, okay. All right, all right, well, the first party to file an appeal is Central Car Company. So I'll hear from you first on your appeal, and then I'll hear the response from that to Mr. Steele, and then he can go straight on to the cross appeal, and then I'll come back to you for your response to the cross appeal. Will you follow that process?
Yes, ma'am.
All right. Now, if you didn't understand what Mr. Steele has just said, is that the 4 invoices that you put in yesterday, and including the amount of money received in paragraph 11, or you're referring to paragraph 11 of your written submission, were not matters that were flagged in the notice of appeal. And so he is saying, I object to the appeal being wider than what was in the notice of appeal. And I'd probably add to that, particularly in view of the fact that he only received the submissions and those invoices yesterday. And so obviously hasn't had sufficient time to sit down with his client and go through them. So he's objecting to those documents going in. Now there's a couple of things we can do about that. The first is that I can rule in favour of Mr. Bing and say, yes, those documents are too late and I can't hear that part of your appeal. And the other thing is that could happen is you could say it's an important part of your case and you could apply to adjourn this hearing to give Mr. Bing time to respond to it.
We, as far as timeframes goes, I am aware of the timeframes. We received these bundles of documents. I wasn't aware we had them until yesterday morning. They arrived evidently by a courier and were handed to a gentleman that was repairing the roof at that address, who handed them to me yesterday morning. Perhaps my learned friend can provide me with an
I don't think that's really the point.
affidavit of service of those documents. However, Mum, the...
I'm just going to have a look here at what directions were made about what needed to be filed and when. Just give me a moment. So I've got a note that Judge Mathers on the 5th of November last year said that the appellant was to file and serve submissions 10 days prior to the hearing, so that's you, which you obviously didn't do, and the respondent to file and serve submissions 5 days prior to the fixture, so there was nothing about bundles of documents directed by the court, but it's reasonably common for lawyers to file what they've filed here, and it's really for my convenience rather than anybody else's, just so that all the documents are in one place and we can all go to them, and so that rather than handing me up case by case, they're all in a paginated form. So it's really one of the tricks you learn as a lawyer is make life easy for the judge. So that's all it's about. It's not linked to advantage or disadvantage you. It's purely for making the relevant documents available in a simple form that we can all go to rather than shuffling with bits of paper.
Thank you, Mum. The change of appealers, we haven't alleviated from the change of appeal, Mum, because there were certain aspects that we had to do on this car after the appeal was filed. We were still having to comply with the orders of the Auckland Motor Vehicle Dealers Tribunal, Mr. Brett Carter. So it was very hard because we were never allowed access to this vehicle. When the gentleman crashed it, he came and told us that he crashed it, and the few things that we had to do to the vehicle, which we agreed to at the point of sale, he wouldn't be able to bring it back in until such time as the insurance company had repaired the car for him. And obviously the insurance company didn't pay out for what he wanted or whatever the case was, and he then misaligned his story to try and place us in the role of the insurance company man, which we're finding insurance companies are doing a lot of at recent times. So we didn't actually get the vehicle apart. We didn't actually get the vehicle apart. And when we did get it apart, we did find these these things that weren't evident until they weren't evident to us, and they weren't evident or available as evidence to the tribunal.
Right, so if I can just stop you there, but we're talking about you did the work on the car in July, August last year.
Correct,
is that
yes.
right? The issue is that at that time you could have amended the notice of appeal to include these things. That's the issue.
The grounds of appeal are relating to the shock absorber.
Where's that? Oh, and B? Yes, well, I think. Yes, right, the shock absorber.
Shock absorbers. I'll just refer you to it, Mum.
And, yes, so.
The grounds of appeal were to the amount that the tribunal the tribunal ordered for storage and for getting the vehicle assessed. Mum, those assessments proved that my point that he was given a hunting licence to go around and try and find things wrong with this car which he didn't succeed on. My argument is, why should I have to pay for that, Mum?
Yes,
So that was
I suppose it's correct that you talked about the damaged shock absorber, and you said it will be given to an independent authority for an opinion.
That's the auto line.
And so you've done that afterwards. The problem is the lack of notice of what happened to the other party, Mr. Finn.
Mum,
In other words, it didn't happen until yesterday.
I do apologise as a layman for overlooking the shock invoice. I take responsibility for that. But as far as introducing evidence as far as the car jam goes, that's something that I only obtained on Sunday, and that shows that the gentleman's done 8,000 Ks in the car since he's uplifted it from my car yard.
Now, where's that?
And it shows that in his statements that he's applied, that the car has just been sitting in storage at a mechanical workshop in Stanley Street in the city, Mum.
So the car jam, is there an invoice relating to that?
The car jam is a facility available to dealers to check.
So you check that?
To make sure that there's no money owing on a car.
Yeah.
And it can also tell you what mileage the car's travelled if it's been in full warrant of fitness in its 6 month or 12 month routine. And in this particular case, I noticed, and I've got it here, ma'am, and I gave a copy to my learned friend.
I am going to take issue with this, but I'll let Mr. know.
That he's actually travelled 8,000 Ks since we returned the car to him last year. And that's, I believe to be a fairly significant point, because that's going to, that's like driving the vehicle to Sydney and back 4 times, Mum. It's not just stored, is my
Okay,
point.
so I can be clear.
Yes.
I probably know less about cars than the average girl.
Right.
But, so what you're saying is that, well, in this sense, that when I look under the bonnet, I know where the radiator is, and I know where to put the water in the windscreen wipers, and I know where the oil goes. That's it. But what you're saying is, just relating to car jam, you got that from a warrant of fitness that's been issued fairly recently to this car, and noticed that the kilometres travelled has changed.
It wasn't recently, Mum, it was in December of last year.
Okay,
And
so between August and December last year, 8,000 kilometres.
yes,
So
and
who knows what's happened since then?
well, he's trying to make out that the car is doomed and gloomed, and what I'm saying, well, and he's saying in his submission,
I understand now.
he's saying in his submissions, Mum, that the car is in storage. It's just another misaligned comment from Mr. Bing.
So the issue is not, the issue here is, a lot of what we do in a court is about procedure. And a lot of, especially in civil cases, it's disclosing all the documents the other side, and did I see that some discovery order was declined here?
There was an earlier attempt to obtain discovery
Of
by
insurance.
and Judge Sharp declined that
That's right,
application.
that's right.
This particular document, just to assist Your Honour, if I may, very briefly, I'm hesitant, but it's generated by a website called CarJam.
Yes, I've got it.
Mum,
I've got that much. So the issue is not that you're wanting to put this in, the issue is that you haven't flagged it as an issue to Mr. Steele and his client until the last couple of days. That's the issue.
it was available to me on Sunday, Mum, so I then went to a VTNZ authorised agent. I showed them the proviso on our form whereby under the Consumer Guarantees Act, under the Privacy Act, I was able to speak to a third party about this vehicle, any issues relating to it, and I found out that that was the mileage of the car. That was the mileage on the Land Transport database. And understandable, but you know, we've also got to make sure that I obtained this yesterday as a layman. Now, it also went on to say that the
Just pause there.
yes,
You just telling me from where you are doesn't bring it into the court as evidence. It has to be as evidence.
okay, ma'am. As far as applications that we applied to the court for informations, we were asking on 3 occasions for the recordings of the tribunal hearing, the audio.
Have you not had them?
The audio recordings. All we received, ma'am, was the written recordings from the tribunal, which clearly stated at the top of the page that they did not guarantee the accuracy or the authenticity of those the written transcripts. So, ma'am, we applied to the courts and we were declined on 2 occasions.
I've got the transcripts here.
And then we were successful in obtaining those recordings.
Yes.
And Lucy Ann, God bless her, she got them for us last week, and we managed to listen to them. But that was one thing that we were declined, but we did obtain in the end by an application to the Auckland District Court.
That's pretty routine these days.
Yeah.
The way we weren't given them. But what I'm asking you to do here is just to respond to the matters that Mr. Steele's just raised with me about new material that's only come to them in the last couple of days.
Mum, could we adjourn to allow, I do apologise and I understand the ramifications, but could we adjourn to allow that? I do apologise for the invoice from the alignment shop. That was my oversight. And the car
Do you want
jam,
all these invoices in?
all the car jam documents need to be entered, because I only received these documents yesterday,
Yeah.
and part of those documents clearly
Have we got
state
the car jam documents in the...
that Mr. Bing,
Now, have I got the car jam documents here? I don't think I have.
I think I sent it through to Star.
What is it?
It's this, I've got a page of it here now.
My instructing solicitor received it at 5:46 p.m. I have a copy of it.
Last night?
Last night, yes.
No.
But Mum, in fairness, I only received their submissions yesterday morning, so it's not fair for him to think that I've been dragging the train, because I responded to that as soon as I read it, and it said that Mr. Bing has had the vehicle in storage. I immediately thought, hang on, and I checked, because that facility is available to me as a licensed
Okay.
dealer. And we're not talking about
Evidence from the bar now?
we're not talking about a small distance, Mum. We're talking about 8,000 kilometres between August and December. Now that's from here to Sydney and back 4 times, and not only, furthermore, the gentleman's trying to claim that there's so much wrong with the thing and so much wrong with the vehicle after we had it AA certified, after we had a warrant of fitness done on the vehicle, after we've had all these things done, in essence, one at the tribunal. He's then trying to mould whatever he wants to say to dodge Consumer Guarantees Act Section 21C.
All right, just pause there. So you're now asking for an adjournment so that you can move on. You would need to amend the notice of appeal, and you would need to provide these documents by way of evidence. I would imagine that an affidavit by you saying what you found out from car jam and attaching these might be all that's needed, although you might want to get separate affidavits from the people that have done this work. Because you see, I've seen Mr. Steele's submission, he's saying there's nothing directly from the person.
Sorry, Mum.
There's nothing directly from the shop stock, for example, to say, I am the manager of shop stock.
Yes.
This is the work that we did. This is what we found, and here is the invoice attached.
Yes, ma'am.
The invoice is kind of fairly curt, isn't it?
Yes.
It doesn't really tell you in detail exactly what's happened. So you want an adjournment to produce that material. Right, so just sit down for a moment, will you?
I'm strongly opposed to there being any adjournment. This matter was the subject of directions on the 26th of July 2019 by Judge Sharp, which granted leave to both parties to file additional evidence on appeal, and directed that happened by the end of August 2019. But obviously the appeal was filed early in 2019 in April, so there's been some backwards and forwards before we got to that point. Judge Sharp, in that minute, can I take you on to that? 93 of volume 1.
Yes, it's July, is it probably?
If Your Honour has on your copy the final sentence of that emailed minute, rather the penultimate, failing that they will not be permitted to file additional evidence. So this question about new evidence coming in has been the subject of quite close case management by the court.
Yes. The only problem is the car jam relates to a later event, doesn't it? It relates to an inquiry that was made by Mr. Murphy recently, and it gives the date of the kilometres on the car as at December, which is 4 months after the end of August.
Yes, and he now raises this. He could have done this search far earlier than he has.
Wouldn't have revealed anything though by the end of August, would it?
Not in all. I don't know, because I don't know how the system actually.
Well,
But my instructions,
You
Mum.
do know, if I can follow up with the Steve, so can you.
Well, my instructions, Mum, is that there's actually a transposition error with this CarJam document, which I need to get into. I've taken instructions on this issue. My position is that this evidence shouldn't come in. This case has been significantly delayed already. It's already been the subject of 2 adjournments.
Why is that?
The first one because of the desire to introduce, I understand, this further evidence in early 2020, and then I think COVID.
What happened in 2020 this year? Further evidence? I see. So this was so the appellant was granted further evidence by the 25th of October.
Yes, it was an extension to that original direction of Judge Sharp's.
Okay. And that was over.
And that's when we see the affidavits of Mr. Thomas came in November 2019. And Mr. Spring.
All right. Yes, okay.
So, I mean, my point is, the rules are the rules and really do apply. The issue of further evidence has been considered. I don't think that this new evidence, even if it came in, would change anything that's relevant to the appeal, but I don't know how far I can take that, because I don't have the evidence in a considered form or an
Yes, fair enough, fair enough. What about this, Mr. Steele? What about we hear the case today and don't finish it, and I give you time, or I give Mr. Murphy time to get this additional evidence in by a certain date, and I give your client whatever time you think you need to respond to it, and then we'll reconvene for an hour. So for whatever amount of time it takes.
I apprehend it will require cross-examination.
Or then we, adjourn for a half-hour hearing or something like that.
I'm reluctant to go down that path because of the...
My difficulty is that Mr. Murphy is not legally represented here. And I can tell from what he's saying is that he feels very strongly that it needs to come in. If he had a lawyer acting for him, I'd be less sympathetic. But he doesn't have a lawyer acting for him. I see that he did have some legal assistance with the submissions, and that's pretty obvious just from reading them. But this is about, it seems to me that this is about evidence that is relevant to this appeal. And effectively a defence to the cross appeal. So that's my suggestion.
Well, I'd rather we proceeded with the hearing on that basis and then we reconvene, but only to deal with this particular piece of evidence, not for a further expansion of the case at that subsequent
What
hearing.
piece of evidence? I think we need to be really clear about what it is.
It's not my evidence, Mum.
No, all right. Well, look, I think I've decided that that's what I'll do, and I'll briefly dictate a decision at the moment, because it seems a shame to waste the time. We're all here now. So what I'm proposing, if you just so that you're clear, and you're welcome to stay seated, it doesn't phase me one way or the other, is that I hear the appeal, and you say everything you want to say. But I think in order to get this additional material into a proper form for the court, you need to represent it. So I think what you need to do is amend the notice of appeal to include the new evidence that you want to bring to support the amended notice of appeal, right? And as I understand it, it relates to the
auto line.
Mileage of the vehicle. Since it was returned to Mr. Bank. And work done on the vehicle. That is reflected in the, so it's shop stock, 1, 2, 3 invoices that were supplied with the submissions.
Yes, ma'am.
You know
Now, is that everything?
Ma'am, may I ask the court if we could have a independent person go and view the vehicle?
No, we
Okay.
can't, we definitely can't do that at this stage.
As you please.
You know, I don't even think we've got jurisdiction to do that. We can get a report from people in relation to hearings, but I'm not sure that that extends to appeals.
Ma'am, could I,
If I could just finish.
Yes.
What I will say is that if this case got to the point where it was over a technical issue, a mechanical issue, or an issue within the knowledge of a mechanic, then probably what I would do is send it back to the Motor Vehicle Disputes Tribunal for them to deal with it, because they do have an assessor as part of their process. We don't here. I can't have someone like Mr. Haynes with it in the tribunal. I can't have someone like Mr. Haynes sitting up here beside me.
ma'am, just 2 points if I may.
No, you better make sure I've got this right.
Right you are.
Okay, so amend notice of appeal, so the mileage of the vehicle and the work done on the vehicle represented by the 3 invoices. Is there anything else that's new?
I just wanted to discuss the point of my friend's delay of the trial, etc. Are we at that area yet, or are we still dealing with the invoices?
No, we don't need to.
Okay. The 3 invoices that I would like to introduce would be the
ones that we've got, the shop.
the shock shop,
Yeah, the one from Mr. Asula someone.
Asula, yes.
Yeah, Bentley Auckland Circuit Specialist and Nestler Automotive. So that's 1, 2.
Haven't we
3,
got Bentley
4,
Auckland?
5. Sorry, 5 invoices.
Haven't we got Bentley Auckland?
Yes, Bentley Auckland.
Didn't we have that in the appeal?
Right, that direction is effectively going to mean that I don't know that we can proceed with hearing the appeal today.
We won't deal with this aspect of it.
I do not see how we would be able to proceed if that additional evidence is unless Ryan's going to sort of receive that to BNA, say on the anticipation that that evidence will ultimately
I'm not
come
going to
later.
deal with this aspect of Mr. Murphy's appeal today.
It seems to me that that is really all Mr. Murphy's appeal is from his submission. Just
He's got something to say about your...
certainly in that case, I think if it's to be evidence beyond simply the mileage of the vehicle, it would be very difficult to deal with the substantive appeal. I had in mind, Your Honour, if it were the mileage only, that evidence could come in, could be dealt with. That wouldn't affect the other issues, I don't think, on the appeal, but allowing further evidence about the work that's been carried out to the vehicle subsequently to complete a new ground of appeal that's folded into the submissions that Mr. Murphy intends to make today on his substantive appeal.
I suppose I can see what you're saying.
I would personally struggle to deal with it on that footing.
Okay.
If it were more limited and simply the mileage issue, then I could understand that, but allowing further evidence. beyond that. And that evidence isn't evidence that is fresh in the sense that I understand Your Honour's reasoning for allowing the mileage issue to come in, that may have only been reasonably discoverable in December, but there have already been directions about fresh evidence for this appeal made. Certainly well before now.
So what Mr. Steele is saying is he doesn't think we should proceed to that law, and I don't understand what he's saying, because a lot of what you say in your submissions is about what you discovered when you looked at the car. But just give me a moment, I just need to look up the rules.
Which rule are you looking for?
I don't think it's going to be one about the journalists for hearings. Suppose I look at the appeals.
Part 7 springs to mind that may just be interlocutory application and the ability to report for correction. Part 18 versus appeals.
Yes, it's a question of whether case management rules apply. I think, I'm just going to look at this. All other cases, a party to an appeal may use further evidence finding with the legal report. Court may grant one only for special reasons for the hearing of the evidence.
And that's on the footing that ordinarily the court would simply assume that the tribunal's findings of fact are the findings of fact.
An example of special reason is that it relates to matters that have arisen after the date of the decision of appeal against, and that are or may be relevant to the determination of the appeal. So that seems to be covered on that.
And that might, on Your Honour's reasoning, justify the mileage issue coming in, but not the other matters.
Well, some of these, if you look at some of the invoices, some are dated December 2019, I think.
Very last one is 3 December 2019, and why hasn't an application been made and the evidence put in? I don't know what justification or reasoning is there.
So am I right that there's no ability to have a rehearing in the motor vehicle disputes tribunal?
Your Honour would have the power to send a matter back.
But only after I've heard the
But you
appeal.
need to determine whether there's actually a basis for the appeal first and decide that. If there was some question that arose, for example, a mechanical issue.
But I'm just saying that in the disputes tribunal, you can apply for a rehearing as opposed to appeal.
I don't understand there to be any.
I don't think there is any right to do that.
There seems to
Do
be
you
a
know, Mr.
Marmouth, we refer to Dr. Danaraj and in front of Judge Christian Fodder in the Auckland High Court, he referred that case back to the tribunal
Yeah.
on the matter of
Yes,
fact.
now what I'm asking here is that certainly in the disputes tribunal, not the motor vehicle disputes tribunal, you've got a choice to either apply for a rehearing or to appeal to the district court.
Correct.
And I'm just asking whether is that right in the disputes tribunal, in the motor vehicle disputes tribunal. I think the answer is there isn't that right, because it's appeals. Let me just check.
Judge Harrison, with the case of Joden Finance Limited and Dr. Mr. Prasad, had the ability to return that back
Yes.
to the tribunal.
I understand that much.
Thank you, Mum.
Yeah, I understand that much.
The procedure for the tribunal, Your Honour, is the schedule to the Motor Vehicle Sales Act.
I've got
I haven't got that, I'm sorry.
I've got it. But that's
But I-
only for appeals. You see, it doesn't deal with applications for rehearing.
I don't think there is such a.
I don't think there is either. Because that's what really needs to happen
Yes.
with new evidence. I know you're sitting there with your heart thinking, Mr. Steele, thinking about the cost to your client. I've felt it myself many times.
Well, I won't be appearing in the tribunal, Your Honour.
True. Yeah. Well, no, but I'm thinking about your client. There doesn't seem to be anything in the act about.
The procedure for the tribunal,
I've
it
got
can
it.
regulate its own procedures and so forth.
Yeah, jurisdiction, tribunal limits on jurisdiction. No, there's nothing about reviewing.
And I think the difficulty one might face if you file a further proceeding is judicata and
Yeah,
issues
of course,
and
of course.
Henderson principles on
Yeah.
that's why we've channeled into here.
No right on accept petition from review.
I'll submit one might to make.
I'll come. So was the evidence of March Spring, that was in by the end of November, was it?
Yes,
No
ma'am.
issue with that.
It was in time.
Yes, ma'am. So was New Day Motors.
But, so what wasn't in was Mr Thomas's evidence, is that right?
Mr Thomas's evidence was in, ma'am.
When was that in?
That was filed on the date that it was, as directed by the court. That was filed on the 25th of November 2019,
So
ma'am.
the car jam and
The car
the
jam
invoices
and the,
attached. Is that right, Mr Steele?
The new material, right?
Yeah.
Yes.
Okay,
Shane Haynes' report was filed.
okay.
Just the car jam and the road shock specialist, which I admit that I overlooked, ma'am.
Right.
And ma'am, I beg your pardon. Circuit specialist cluster.
Well, it's really all of those 5 invoices,
I only got yesterday actually because he forgot to send it to me.
because why?
It was a error on his part. He hadn't been paid because he had overlooked to send me the invoice.
Who was that?
That was circuit specialist, which were the folk that did some specialist electronic repairs on that car.
Is that the warning lights?
No, it wasn't the warning lights, it was the stop-start button, the hazard warning light switch, which was causing all the other defects. It had water dropped in from the sunroof, which had
Was
affected,
affecting other,
which was affecting other things in the vehicle. By repairing that, it sort of Mr. Bing was made aware of that pre-sale.
and have I got this right that a lot of what you want to say now, material's just been talking about, is relevant to whether the nose to tail accident that Mr. Bing had on the 9th of April, was it?
28th, I think, ma'am.
28th of April? That accident was the cause of some of the damage to the vehicle,
It's essential.
rather than it being pre-existing?
Absolutely, ma'am.
And that's mainly relates to the right front shock of the right front airbag, is that right?
Yeah, the shocks are airbag, mum, and
The shock what?
the shocks are an air shock,
Yeah,
and they call them airbags in mechanical terms.
that's at the right front of the car.
Correct. And the essential aspect for me, and I do apologise again to the court, is the raised shock specialist invoice, which I will get done in affidavit form. He is a specialist, where he claims that the bushes or torn out centre tube out from the vehicle being too low after the accident.
When did he do that work?
He did that work on the 29th of the 10th of 2019.
Had the car been given back to Mr.
No, Mum. We still were waiting for the shock absorber to
When did the
arrive.
car go back to Mr. Thing?
I'd have to refer to your
Do you
records.
know?
Early December, Mark.
There was
Could
delays
it have run off all of that mileage then?
from December to no, he wasn't given the car back. When he was given the car back.
And then
It
you got
wasn't.
it back again?
No way, Mum. Sorry, he was given the car back not in December. I'd have to refer to my my notes as to when he got the car back.
It was returned pursuant to a consent order of this court on the 6th of December 2019.
Mhm. And you got it in July?
April, he took delivery of the car,
Yeah. And you got it back in July?
and then he would never allow us the vehicle back, and the tribunal then ordered that he gave the car back.
So that
And
would have been between 2018, December 2018 and the hearing in
would have been-
January 2019, would it?
it would have been after the result of the hearing.
Yeah.
Even then, the adjudicator had to have another hearing because of the Mr. Bean didn't want to drop it off until we had done this, that and the other.
Yeah.
And so he called another hearing, which he said was not a hearing that he could do, but it's on record somewhere. And that's where Mr. Bean was ordered to bring the car back. We then ordered the parts for the vehicle. We put the shock absorber in that we got in from Germany, and it exploded straight away. And that was because there was further damage done.
No need to give me all that detail.
Yeah, okay. It's been a very trying time dealing with this, Mr. Bean, Mum.
The vehicle was returned on the 15th of April 2019 to Central Car Company, following the delivery of the tribunal's judgment on the 9th of April.
And it was there all that time?
My understanding is, until it was returned pursuant to the order of, I think, Judge Harrison, as part of case management in this proceeding.
Steve, would you mind just popping upstairs? I think this one might be a little complicated. That's what I started writing some more.
Just trying to find the document.
Can you put it down?
Sorry, I misled you. It wasn't Judge Harrison, it was Judge Mathers that directed the vehicle be returned. And that's that 5th of November minute of her
If you're unlocked, Mr. Steele, have you got all the directions that have been made by the judges?
Not all of them. The only direction that I included was the minute of Judge Sharp at page 93.
That's all right.
I can hand up a copy of Judge Mather's minute. I have a copy of that.
I can read her writing anyway. Sorry, if you could pass that notice up to me, because I can't find it.
That's Judge Mather's minute of November 2019 and Judge Sharp's earlier minute, which set the procedural directions and allowed for the filing of further evidence.
And then I've got Judge Harrison.
He extended the time for the filing of that evidence. I understand I haven't got a copy of that minute, I'm afraid.
11th of September.
That would sound about
The
right.
appellant has granted leave to file temporary evidence by the 25th of October. The application for the return of the vehicle is to be served on the appellant and reviewed at the CMC on the 5th of November.
And that's what I've just handed to Your Honour as the CMC of 5 November.
That was extended again.
Yes, and I think at that time the hearing was scheduled for January of this year.
At that time though, by the, Mr. Steele, by the 5th of November, with Judge Mather's direction, hadn't some of this material been filed about what had happened to the car since the respondent had been fixing it?
There were 2 affidavits filed, and
That was Mr. Thomas
the affidavit of Kenneth Thomas
and Mr. Spring?
and Mr. Spring, but his evidence is addressed to the value of the vehicle, not so much the repairs or any work that was carried out.
Still relevant, isn't it?
Oh, it
And
is, and I don't think
Mr. Thomas's evidence was about the brake payment.
it's about a vacuum hose system. Yes. So the appellant put in the evidence that it wanted to put in accordance with the directions that were made.
I suppose the point I'm making is that you were on notice by November last year that what had been done to the car since was very much an issue.
Yes, and the evidence was put in and understood as it was in terms of the directions made for final evidence. I'm happy to deal with Mr. Thomas's affidavit and Mr. Spring's affidavit. It's the very new material that I take an issue with. It could have been provided for now. Clearly could have been provided for now. Your Honour's helpfully worked through the chronology to that effect. So to adjourn the appeal further, after it's extended interlocutory history, and this is the point I make in that small memorandum I handed up to Your Honour, that it's not in the interest of justice for it to be adjourned further. The other point is that an appeal from the motor vehicle dispute needs to be brought within 20 working days. If there's going to be an extension or enlargement of the notice of appeal, there needs to be some reasonable justification for the amendment. It's a small point, but my client's strong preference is to get on and have this appeal dealt with.
I can understand it, just have a seat.
On the basis of the evidence in accordance with the procedural rules of this court and the directions made by 3 different judges.
I understand. Is the date of the date of the Bentley invoice seems to be April 2019, is that right?
If that's what it says,
Well,
ma'am.
it doesn't actually. I can't see a date on the invoice itself.
Stand by and I'll just...
But there's a little, like a printout of the receipt.
There is in the corner, I noticed that yesterday, yes.
That corresponds with the amount paid, that FPOS docket that's been attached.
It's in the net cost.
A little printout that one gets when you
It's your submission.
pay by FPOS or credit card, I think. So it's been attached.
I have the original here, ma'am.
So you agree it was 20 April 2020?
It was the 26th of April
2019.
at 14:10, and I paid for it with my American Express card.
In 2019?
Correct. That's when I paid for it. That doesn't necessarily mean
What was earlier?
that doesn't necessarily mean to say that we got the part on that date because it had to come from the United Kingdom.
Okay.
Got to go through a bit of a loop there. Sometimes Singapore they come from, but I believe that had to come from the UK.
That was before the appeal was filed.
So the last one, the Mr. Automotive. is it? Lisa Automotive? I see there's a date of the 18th of October 2019, but it doesn't tell me.
Oh, ma'am, I beg your pardon, yes. That is the second airbag that we had to get for the vehicle that had to come from Germany. Because the first one blew.
Yeah, okay, yeah, but when did you get it? I mean, that looks like something like, almost like a consignment note, doesn't it?
Yes, once again it had to come from abroad. And from memory I think it came from Germany. And
German. Rechnungs.
yeah, they're very good to deal with.
Abrechnungsnummer.
And
There's actually two of those invoices referred to in paragraph 11 of the submission. I've only seen one of those.
the gentleman that was helping me with this car, man, died halfway through. Mr. Ashley Palmer passed away, so he had a very good dialogue of it all. He did all my dealings with this sort of thing. Now the
Right, so I see in paragraph 11, so you've got Nissan
Not that that amount corresponds.
Auto one. No, but that'll be in euros, won't it?
It is, the invoice is in euros. I'm not sure how the conversion's been done at different dates, and it doesn't quite add up to me, but I don't.
It's about 600 euros.
there'll be euros, ma'am. There'll be GST, and there'll be tax paid at a certain percentage of the value of the goods that were purchased.
Right. Okay, that makes sense.
Maybe
That
so.
makes about 1,200.
Probably don't know.
Depending on the urgency of the job, there's also additional costs with freight. It's quite an expensive, bulky thing. I've kept them both. And sometimes if you've got dates set or deadlines set by the appropriate courts, you need to get them done post haste. And as far as the second one goes, we got it and it's installed on the 29th of the 10th of 019.
Can you tell me when Mr. Thomas's affidavit is?
At page 69 of volume 1.
And is Mr. Springs nearby?
It's the next document in that only starts at page 89. Is there no indices on your honours?
No, there isn't.
I'm very sorry about that.
That's all right.
We all make
Next
mistakes.
time, just
I'll have a word with the instructing solicitors about it.
well, just
We all make mistakes.
about it. Right, well, I'll hear from you, Mr. Murphy. In essence, what Mr. Steele was saying to me was that this has been a long time, we've had the decision from 2019, which is now 15 months ago. And there have been 3 lots of directions made by judges, firstly Judge Sharp, then Judge Mathers, and then Judge Harrison, about further evidence. Mr. Steele is essentially saying that's enough. I should proceed with the appeal today and not give you any time to file further material. So he's urging me to decline your application to adjourn the case. And in support of that, what he's pointed to is that new materials in terms of the invoices is being presented at this late hour when it's obvious from the dates on them that they could have come in earlier.
Mr. Steele is trying to lead the court to believe that
he's not trying to do anything that's improper,
Okay.
Mr. Murphy. You know, it's an application that any lawyer would be bringing at this stage.
We've had dates of the 16th of April, which we were ready to appear on. We then had COVID came along. We then had the court then gave us an urgent hearing date, which was about 2 or 3 days coming up, and this gentleman's lawyer said, no, we haven't got time to prepare. I've been ready and available at every single point to have this case heard, ma'am. There's not one stage. It's Mr. Bing is either going to England, he's doing this, or his counsel can't be informed.
That's not really relevant.
Yes, I understand, but it's not.
So are you saying latitude's been given to him, so it should be given?
No, ma'am. We've had COVID. I can't say that. What I can say is I've got 6 staff and I've got a business I've been running for 40 years, which is really struggling at the moment. And this has given me nothing but consternation to the point where I've spent, all Saturday, all Sunday on it. I haven't got a lawyer. I'm trying to do the very best that I can. The legal advice that I'm getting, I believe, to be first class. Sir David Crothers knows that I'm getting the advice from somebody that is in prison. And so all I want to do is to have the matter heard. I have apologised to the court today for this order alignment invoice that I just clearly overlooked it, ma'am. I just clearly overlooked the order alignment.
The circuit specialist, though?
Well, that doesn't really matter because it's been fixed, and I had agreed all the way through to have it fixed, and I've done so. So,
It's the shock one.
The last invoice which I found yesterday from Shane, from the auto electrical shop, was relating to the dashboard. Well, I haven't heard from Mr. Bing as if it's not working. I'm sure I find it difficult to trust anything he tells me, but we did find out through that invoice that it did get repaired. It was placed back in the vehicle and it did rectify the hazard flashes going on and off and lighting up the so-called dashboard, and it also rectified...
Was it the shock stop one?
No, the shock stop one is the important one because that's the one that I overlooked to put in, ma'am. It was my mistake and I apologise to the courts for it. It is significant because it shows that after the accident that the inner bushes were taken out because he continued to drive the car, although caused it the accident, hence costing me another shock to put in the car. And that was an expense, as you can see. Mr. Palmer, before he died, he made one thing quite clear. He said, "You get justice on this case, John." We've spent a lot of money on this car. He bought it, he admitted at the tribunal. I know you don't want to hear it, man, but he admitted at the tribunal. I explained all these defects to him, and he has just not backed off 1 minute. And his stories, even by the tribunal, have said they're malleable. They said they're just simply not true. He is always telling me about his future court cases. He's going to England, he's doing this, he's doing that. I've been ready to rock and roll at a moment's notice, ma'am. I'm sorry, I forgot to put the invoice in for the alignment.
Well, it's more than that. I mean, it's 5 new invoices, isn't it? And it is
Well, the bumper,
the car jam material.
the car jam material is probably irrelevant, ma'am.
Well, I must say I am wondering about that.
It could be irrelevant.
It does seem to me that over that period of time,
Yeah.
that I don't know whether you took any notice of any note of the kilometres, but it seems to me that you had the car for 6 months prior, so it's a bit of a puzzle to me about how he could have driven them.
He did 500 k's in one afternoon, remember?
Yes, it's true.
So I don't. What I've got to be is very careful with this chap, because he will run around and find a hook to hang his hat on.
Try and focus on what we're dealing with.
And what I'm dealing with is a guy who speaks with a forked tongue. So I've got to be very careful. And the most important thing for me is probably his credibility's gone in my view, but probably this invoice that I got from the shock shop. You know, all these things cost me over 10,000, man. It's not as if I've been lying and doing nothing for him.
No, true.
Then I put a shock in it and it explodes. I wasn't very happy that day, I can tell you. My businesses are losing money. The only reason I'm still in business is because I'm a multi-millionaire and I'm subsidising workers at the moment, and this sort of thing just absolutely rats me up the wrong way. I've done my best for him. I've put up with all his, whatever, but he will not get away with it. I am known, ma'am, if I think that justice hasn't treated me in the district court, I'm up the High Court, and I've got one at the moment on. So I've offered to settle when COVID came along. My settlement was more than fair.
Shouldn't be telling me.
I know that, man, but I have. I don't want to be here today. I've got staff I've got to pay. I've got 6 of them, and they're working on my car, cleaning cars, rather than walking around the streets of Glen Innes. So, in a minute, it might get too hard for me.
Just take a second.
Have a rest, bro.
Thanks, man.
Well, it's Central Car Company's appeal. If it wants to have it heard, it can get on and have it heard today on the basis of the evidence that's put before court. The other factor, I think, is that's all I want to say. I think you've got the evidence.
I'll give a decision. At the beginning of the hearing, Mr. Steele for Mr. Bing, who is the appellant in the cross-appeal and the respondent in the appeal from Central Car Company, raised with me an issue about new material presented by Central Car Company in the last 48 hours. He objects to the new material, which falls into 2 categories. 5 invoices relating to work that's been done on the car by Central Car Company following the decision of the Motor Vehicle Disputes Tribunal. Decision that was dated the 9th of April 2019. Secondly, some information that is in the submissions, but there is no evidence to support it. But I'm aware from what Mr. Murphy has told me today that he has made inquiries as to distances this car has travelled at the time that it received a warrant of fitness sometime in December last year. Both of those issues are important to the appeal from Central Car Company. Central Car Company then made an application to adjourn the case so that it could present this new material in a proper way. That's objected to by Mr. Thing for essentially the following reasons. That there has been ample time to file the new material, particularly against a background of 3 different judges on 3 different dates of this, 3 different judges of this court on 3 different dates, making directions that included additional evidence. The first was a decision of Judge Mary Beth Sharp on the 26th of July 2019. Both parties were granted leave to file additional evidence by the end of August 2019. That was revisited by Judge Mathers in July 2019. The date for filing further evidence was extended to,
I don't have that
I've got it down, I've found it down, was extended to the 20th of November 2019. I see from the file that there were then issues about Mr. Murphy from Central Car Company getting access to the tribunal hearing. I beg your pardon, just changed the date that Judge Mathers made those corrections as the 5th of November 2019. That happened only recently. Sorry, could you go back and slot this in, please? On the 11th of September 2019, Judge Harrison extended leave to file further evidence till the 25th of October 2019, and then go on to Judge Mathers' corrections on the 5th of November. In support of the application for the adjournment, Mr. Murphy has told me that he overlooked an invoice from a shop who did work on the right front air shock around October 2019. In relation to another invoice from the circuit specialist, which is not dated but has a due date of the 20th of January 2020. Mr. Murphy tells me that he only came into possession of that invoice very recently. The way he came into possession of it was that circuit specialist was pressing him for payment.
No, ma'am.
I know.
No.
I thought you said they hadn't been paid.
No, they
And
hadn't.
you asked them to send through an invoice.
They hadn't sent me through, they hadn't, I pay all my invoices on the 20th, I run a proper business, and none of my invoices are in arrears. We do occasionally get tradespeople that just simply, these are,
Okay, I think I've got that.
yeah,
When he was being asked for payment, he told circuit specialists that he didn't have their invoice and they then supplied it.
correct.
That's why he's only come into possession of it
Yeah.
recently. In terms of the mileage of the vehicle, Mr. Murphy tells me that he made inquiries about that over the weekend that's just passed. He was able to obtain information about the mileage on this particular car by talking to somebody at BTNZ. I then explored with the parties whether it was possible to hear the appeal without dealing with this aspect of it. And Mr. Steele then submitted that, in fact, the case that Central Cars is wanting to bring is based on what they found when they fixed the vehicle. And that was over a period of at least 6 months in 2019. Therefore, the notice of appeal hasn't put Mr. Bing on notice of this change in circumstance, and he is therefore not prepared to deal with it. I say prepared in the sense of having the material in order to be able to respond to the evidence brought by Central Cars Limited. The material that was filed included an affidavit from a Mr. Thomas who tested the car inspected and tested the car. And actually he doesn't say when.
21st of November, I think, ma'am.
It doesn't say when in the affidavit.
In my friend's submissions, rather Mr. Murphy's submissions, he says the 29th of August.
Yes, it does. What the affidavit says is that he's read the affidavit of Mr. Martin filed on the 29th of August 2019, so I'm not too sure that that's right. Certainly one issue that he does raise is whether damage to an airbag, what's called an airbag, at the right front part of the car was damaged in a nose-to-tail accident Mr. Bing had, or whether it was pre-existing that accident. What's in the submissions of Central Cars Limited is that they have spent $10,364.82 to get this car repaired. And given that the car cost something like $39,000,
$36,995.
$37,000,
$36,995.
that's a significant sum of money. Mr. Murphy's told me from the bar that in fact they've had to replace his airbag twice. This is the first time they replaced it at first. This is a Bentley car and parts have had to be obtained from Germany. That's part of the reason that it's taken so long to get the car fixed. The affidavit of Mr. Thomas also talks about the brakes, which were the subject of a report by the assessor and the tribunal. I now turn to the law. The Part 18 of the District Court rules is relevant. There is very little about how an appeal is to be conducted in the Motor Vehicle Sales Act and Schedule 1, which deals with appeals. Rule 18.2 states that the court has full discretionary power to hear and receive further evidence on questions of fact, either by oral evidence or by affidavit. I and mindful of Rule 18.7, which says that a party to an appeal may only adduce further evidence with leave of the court. Such evidence is not usually allowed if it could have been produced at an earlier stage. That usually relates to whether or not this evidence could have been before the Motor Vehicle Disputes Tribunal, and it goes without saying that in this case the evidence that we're talking about has not. In Ray against the International Insurance Brokers, Nelson Marlborough and Roberts Limited 1983 in ZLR at 190, the Court of Appeal said that evidence that is not fresh should only be admitted where there are exceptional, where the circumstances are exceptional and the grounds are compelling. That's not what we've got here. This is fresh evidence. The evidence must pass the tests of credibility and cogency. Cogency requires an assessment of how strong the proposed evidence is and whether or not it's likely to affect the outcome. Relying on Hodgson and Hodgson, HODGSON 2015 NZCA 404. In terms of deadlines made by previous judges, it was the end of November 2019. I have at least two pieces of evidence that Central Cars Limited wishes to rely on, which post-date the end of November 2019. In terms of the invoices themselves, one is the document from Circuit Specialist, which Mr. Murphy tells me he only received very recently. In any event, I note that the due date on that invoice was the 20th of January 2020, so presumably it was issued in December 2019, which postdates the November deadline. The information we have about the second airbag that came from Germany is a document that doesn't, that may not even be an invoice. I say that because it's expressed in euros. The date is the 18th of October 2019. We don't know whether that was the date it was dispatched from Germany, and we don't know the date that it was received in New Zealand. I imagine with some time Mr. Murphy would be able to tell us when that airbag arrived and when he received an invoice that required him to pay it, or whether he had to pay it in advance. He was able to tell me, and which information is in the submissions, that the amount paid by Central Cars for the airbag was $1,750. The date is the 18th of October 2019, which is the same date on the invoice, but we don't know when exactly that. I don't know whether or not that was exactly when it was paid. Some of the other invoices could have been presented earlier, and Mr. Murphy was quite frank in telling me that he overlooked the shop stop invoice, and that's an invoice that is very relevant to this appeal in terms of the way it's now framed by the by Central Car Limited. And I say that because there is a causation issue about whether the damage to the right front of the car happened because of the accident, or whether there were pre-existing issues with that part of the car. I am aware that there's some evidence from Mr. Bing, on behalf of Mr. Bing, that the brakes may have, or the issues with the brakes may have been responsible for the fact that he was not able to stop in time when he hit a stationary car at an on-ramp onto the motorway.
Off ramp, ma'am.
There is another factor that is very much in my mind at the time of this application, and it is that Central Car Limited is not legally represented. In relation to that aspect of the matter, Mr. Murphy's made it plain that the effects of COVID on his business have been detrimental and serious. And that the business is, in his words, struggling. That may be an explanation as to why he doesn't have a lawyer here with him today. I am aware from his submissions that some legal assistance has been provided, but unfortunately that hasn't extended to the need to amend the appeal document and to present this new evidence in a proper way. In my view, it is in the interest of justice to grant the adjournment. And I say that because it should have been apparent, well, it is apparent to me that the focus of the appeal is now changed completely for Central Car Limited.
Car Company Limited.
Central Car Limited?
Central Car Company Limited, ma'am.
The dispute is now about things that have been found with the car since the repairs have been carried out. And there's also an argument about betterment, which means that because of the repairs that have been carried out, the car now has a greater value to Mr. Bing than it did when he bought it. That was alluded to in relation to that was alluded to in relation to the bumper at the front, but not so much in relation to other parts of the vehicle that had to be repaired. If there were not a cross appeal, I might have made a different decision. But it does seem unfair to me that Mr. Bing would be allowed to effectively run his case as he wants to on the cross appeal, while Central Car Company Limited would be hampered if I made them proceed today. And had they not filed an appeal in the first place, then Mr. Bing wouldn't have had a cross appeal. So it seems to me that it is in the interest of justice that I adjourn the hearing, even though we would all like it to have happen today for various reasons. So we'll keep that typed up, please. Now we'll just make some directions. Mr. Murphy, I'm going to restrict your ability to file further evidence for the material that you have filed today. Alright, that's adjourned. Of course it's a matter for you and Mr. Murphy, but I would strongly recommend that you do instruct a lawyer to appear. or at least to do the work to get this appeal in a fit state to be heard. Central Car Limited is to file further evidence on one, the mileage the car has done, since it's released to Mr. Was it a 1 year warrant? Would be 6 months, wouldn't it?
Depends on the year of the car, and that was the first of the new shape Bentley, and I see, looking at the car, Jim, it was manufactured in December 2005, so hence that would now make the car
6 months.
6 month warrant of fitness.
Okay, so
Land Transport Act.
since
We put a new
it would be
warrant.
since
28th of April 2018, we put a new warrant of fitness on the car, and that was the date the gentleman took delivery, Mum.
since the 28th of April 2019.
Warrant of fitness was issued and it's in the pile.
Alright, so mileage the car has done since the 28th of April 2019.
2018, sorry, Mum.
Right, 18.
20
And repairs to the car not previously, the cost of repairs not previously in evidence. Now that includes bringing the invoices in a proper form, do you understand that?
Yes, Mum.
Bringing the 5 invoices and what we're talking about in a proper evidential format. That's it. Now how long do you think it will take you to do that? 3 weeks from today?
Yeah, that's fine, Mum.
Alright.
1 month, I've got to get hold of my guy who's in Rimutaka prison. And to
Okay.
do that, I've got to go through a process.
Alright,
so
a month?
1 month would be great, yeah.
Okay.
Mum, he was asking if he could appear as my Mackenzie friend. He's been in prison for 21 years. In that time, he's obtained the highest degree you can in law and accountancy.
Well,
And he's,
that just sounds far too complicated to be
Yeah,
quite
okay.
honest.
Sorry.
You would have to appear by ABL, it just sounds out of question.
Roger, thank you.
A month. 22nd September, that's
That is the one before that, it'd be the
15th.
15th.
that's a Tuesday Tuesday today to Tuesday's 15th September.
We'll make it the 16th of September.
Yep, that's a Wednesday.
How long would you like to reply, Mr. Steele? I'll just ask Steve.
I've got no,
Realistically, how are we looking in terms of hearing dates for a one-day case? Do you know where they're up to?
The schedulers are finalising long course fixtures for mid-November through December, which is a very narrow band of available
Okay, so
dates.
nothing's going to happen till mid-November, is that right?
Correct.
Okay, so we'll give you a month to Mr. Steele to reply by the,
if you could just reserve leave in case that becomes
okay, so
problematic.
that would be a month from the 16th of December, would that be
14th.
14th of October?
Correct, Mum.
2020. Now, leave granted to apply to amend Now, I'm going to say, court to allocate 1 day hearing. 6, any additional submissions? To be filed and served.
It's just 10 and 5 again.
I think that, no, we've got the main ones. Let's have additional ones at the same time. 5 clear days before the hearing. You know what you're facing now. 5 clear days before the hearing. Anyone, you're not happy about that, Mr. Steele?
I'm in the court's
Well, you've got your submissions in on the cross appeal. It's only submissions in response to new material filed.
And I'm sure that the new material will be quite extensive and I'll just have to deal with it. That's fine.
Before 5 clear working days. Right, so that means, everybody, that means that if the hearing is going to be on the 16th of November, those submissions need to be in by the 9th of November. Filed with the court and served. Let's have no more of this. I got this yesterday, I only got this on Tuesday, I only got this on Monday. Now that will be typed up as well, won't it, Steve, and sent to you. I'll tell you what else too, I'll reserve costs on the adjournment too.
I was going to say wasted cost order in the circumstances. My client's been put to the cost of preparing for this hearing, being ready to go with his cross appeal.
Yeah.
He faces everything coming in at the last minute, no submissions from the appellant. We've consumed.
Have you got a sum in mind, Mr. Steele?
Something in the order of $1,500 now.
Well, it's really for being here today, isn't it? Because your submissions had to be done anyway.
I needed to prepare, but there'll be some re-preparation, so I guess, you know.
You can seek those at a further time. You can seek those at a further time. It seems to me, Mr. Murphy, that it's reasonable to order costs to Mr. Steele's client on the adjournment. The reality is that Mr. Steele has been here for at least 3 hours.
Mum, it works both.
And your application, you haven't.
It's an indulgence, Mum, is my proposition.
Mum, it's not fair on the grounds that they were all, the only reason I went to get the car jammer's report was because it was written in his bundle that I got the other day, Mum.
Yes, but it's not the only issue, is
No,
it?
but that's one issue, and where there's one issue, they're lawyers, they should know better. I'm a layman that's struggling with a business. And, you know, I'd appeal, cost appeal, man.
I'm going to make an order and pay to Mr. Fling on the sum of $750 for today. Thank you.
Mum, and just...
I've made the order.
Yeah, that's fine. Just one thing, at a recent district court hearing we had, we got to this point of the hearing and we were going nowhere, and we asked that the adjudicator would help us try and broker a settlement, which we were successful in doing. And the matter was put to rest. Are you able to assist us in that today?
How do you feel about that, Mr.
I find that
I've got time this afternoon.
this lawyer here is he's been quite reasonable to me to talk to. He seems
Very
like
reasonable.
quite an
but,
approachable
he hasn't got
subject.
his client here as part of the problem.
I've got no instructions. I'd be happy to obtain those instructions. If I can speak frankly, this is a case that just needs to be resolved.
Yes.
And on and without prejudice basis.
I negotiate with people every day, ma'am.
Why don't you do this?
Yep.
Mr. Steele obviously have to ring and see if Mr. Bing's available to come this afternoon.
Well, even if he could do it over the phone.
Well, that's possible too.
Yeah.
But what I'll do is, Mr. Seal can ring Mr. Bing.
Yep.
And you can exchange numbers, and he
Right.
can let you know whether Mr. Bing's available this afternoon.
Yep.
And then I'll get you to contact Steve
Yep.
to let him know whether we can do that. I can make myself available
Thank you, Mum.
to do
Sort of.
that this
Okay.
afternoon
Yeah.
if that gets you more sorted.
I'll see what I can do.
Yeah, in fact, the other option, Steve, would be tomorrow morning.
Yeah, that's fine.
I was actually given judgment writing time for
Yes,
this
ma'am.
tomorrow morning. Have you got a court available? Or is
I'd have to double check that.
That wouldn't.
that wouldn't work for you?
I've got a 3-week fixture starting Monday, Mum. So
What about an
I'm
AV,
against it.
a telephone conference? We've done those in the past.
Well, I'll leave you to talk to Mr. Steele,
Yeah.
and if you can organise it, I can be available.
Yeah, okay. Thank you, Mum.
All right,
Yeah.
thank you.
Much appreciated. Thanks for your help today.
What will it do?
If you can get hold of them, just, I don't know,
What is, I,
what's this? I don't want to muck you around, mate. You know, we've all got business.
no, I understand that.
I'm just sick and tired of the malice and all the toing and throwing going on.
Well, do you want to just step outside? Can I just have a quick chat to you?
She's a very fair judge, though, and she's probably more